Big corporate story of the day, which has emerged from the Supreme Court today. The Supreme Court of India finally released its order, its verdict in the long-standing Tata-Mistry case. It's a feud, a corporate battle that has been running since the last 4 years, ever since Cyrus Mistry was ousted from the board and the helm of Tata Sons. Since then, the battle has wound its way through several courts, the NCLT, the NCLAT, and now finally the Supreme Court. Now, the Supreme Court very clearly has ruled in favor of Tata Sons and overturned the appeals of the Mistry Group. Let's first go across to my colleague Abhimanyu Sharma, who's outlining for you what the court said today.
Half a decade-long high-pitched corporate dispute laid to rest with a crisp and concise judgment pronounced in less than 5 minutes by the CJI-led bench. The Supreme Court has allowed appeals by the Tata Group and has set aside the NCLT order which had reinstated Cyrus Mistry as chairperson of Tata Sons. The Supreme Court has upheld the decision of Tata Sons, which was taken in 2016 to sack Cyrus Mistry as the chairperson of Tata Sons. He was serving on this position since 2012. The Supreme Court has also refused to entertain Shapoorji Pallonji Group's plea for fair compensation for their equity shares in Tata Sons. The court noted that the value of the SP Group shares will depend on valuation of Tata Sons equities, and the court will not go into determining what should be a fair value. The court noted that well-settled principles of law were overturned by the NCLT and left it to Tata Sons and Cyrus Mistry to take the legal route to resolve the issue of valuation of shares. Also, the court has dismissed petitions filed by Sterling Investments and Cyrus Investments while ruling in favor of the Tata Group. Of course, the legal route which now would be taken for valuation of the shares will be a long-drawn one, but as far as sacking of Cyrus Mistry is concerned, that issue has been laid to rest by the Supreme Court.
Let's go across to our panel to understand whether this fight is truly over. What happens next? Because the question of valuation of the Shapoorji Pallonji stake is still there. It's still a question mark. VR Mehta joins us, board member, Tata Trust. Prabal Basu Roy, advisor, chairman of corporate boards, joins us on the show as well, as does Anil Singhvi, founder, Ican Investment Advisors. Welcome to all of you, and thank you so much for speaking with us. I want to first just read out, before I start the discussion, what Ratan Tata said today, and he put this out on social media. He said, "I appreciate and I'm grateful for the judgment passed by the Honorable Supreme Court. It is not an issue of winning or losing. After relentless attacks on my integrity and the ethical conduct of the group, the judgment upholding all the appeals is a validation of the values and ethics that have always been the guiding principles of the group." And he says it reinforces the fairness and justice displayed by our judiciary. Mr. Mehta, was this a very personal battle at the end of it? I know it's a big corporate battle. There are huge sums of money involved. There are boards involved. There's articles of association involved. But at the end of the day, looking at what Ratan Tata put out, it's also a very personal battle, isn't it?
It was not a personal battle as such, but the fact of the matter remains that the Mistry Group did make personal allegations against Mr. Tata and also against the group for mismanagement and minority oppression. Now, so this was hardly a case of a personal pick between the two groups or the two leading persons of the groups. That would be my take on this aspect.
Okay, let me go across. Okay. Let me go across to Prabal. Prabal, we've been tracking this case so closely over the last 4 years, and I've often had a chance to speak to you about it. At its conclusion, is it finally over? How do you look at the developments?
Tamanna, I had written about this in the Economic Times in 2018. post the NCLT judgment that in our legal system, the substantive part of the issues which were raised by Mistry will have no scope for redressal, purely because the letter of the law has been followed by the Tatas, and it's almost impossible to prove oppression and mismanagement in this case. The courts will not intervene in cases of poor business judgment. They will not intervene in cases of value erosion of investments, poor capital allocation decisions, and so on and so forth. So therefore, even a powerful minority shareholder like Mistry was unlikely to get a redressal, on this count on the courts. So it's hardly surprising to me that the plea has been dismissed. Having said that, the substantive part remains outside the purview of legal jurisprudence, in my view, and therefore will continue to fester. So the question to ask is, has there been a closure on this judgment? I would say legally, yes. Corporate governance perspective, it is doubtful.
Anil Singhvi, where does Cyrus Mistry go from here? Because there's still the little question of 18.4% stake of the Shapoorji Pallonji group in Tata Sons. And the difference of opinion in valuation is stark. It's a 1 lakh crore rupee difference. While the Tata Group values the stake at 70 to 80,000 crores, the SP Group values it at 1.75 lakh crore rupees. How do you think that leg of this is going to pan out?
I'm glad you raised this question, Tamanna, because I think I'm hearing since morning all this that, yes, the judgment has gone in favor of Tata. Mistry had no locus, whether he was ousted from the board correctly, not correctly, and the allegations from both sides and all of that. But I think in the midst of this whole chaotic situation since morning, everyone has missed on this, that he continues to be the largest shareholder. Okay? Because when the shares are owned by trust, these are held in trust. These are for the large public causes. So who is the largest shareholder in terms of wealth? It's Cyrus Mistry and family. The trusts are using this capital, using this money for larger public good. So as far as minority shareholder concept is concerned, this is almost a clear case to me that this is the family which owns 18% shares. And if suppose for some reason Tata Sons and the board and everyone feels that Cyrus Mistry is not a desirable person, then fact of the matter remains that what is the solution? Has Supreme Court provided any solution to this problem? Because ultimately when you say dismiss the NCLT judgment completely, now what are you saying here? That he should not be reinstated, Articles of Association is right, Tata Sons has all the right to not to allow to sell the shares, not to allow to pledge the shares, all of that. Then what happens? Are we suggesting that this 18% is a write-off? And this is not a write-off. Then whatever Tata Sons says or the owners of Tata Sons says that what should be the value, should that be taken as a value or a fair valuation should be done? If a fair valuation should be done, then Supreme Court should have gone ahead on that to put the entire case to rest by appointing 3 valuers, asking each party to appoint 1 valuer and 3rd valuer could be appointed by the court. Something should have been done to put this entire matter to rest. Because Cyrus has filed this also that he doesn't want to be reinstated. Though NCLT may have granted him this, that he should be reinstated, but he said, I don't want to go back as executive chairman. So I think this was already considered.
So do you believe that the entire matter has not been put to rest? No, fair enough. I want to stick to the point of valuation because that's the only outstanding question. Is the matter not at rest in your view?
Tamanna, let us examine this matter. What is the matter now pending on this? The matter pending today is that Cyrus Mistry and family own 18% shares. How will they get an exit and at what value? I don't think there was any other issue left on this. I don't think Cyrus Mistry ever said that I should be reinstated as executive chairman and all of that. No. Publicly he said that I don't wish to be executive chairman of Tata Sons, even if the Supreme Court decides me to be on that. So today the matter is only very simple. What happens to the 18% shareholding? Are we saying that this 18% shareholding does not exist? Or we can lock it so much that nothing can be done? If that be the case, how will India ever attract capital? How will you have a private equity who owns significant minority shareholding in a private limited company? Private limited company cannot be taken as an individual firm. A company which borrows money or takes a capital by nature and conduct cannot be just a very, very proprietary shop. It has to have its own corporate governance. It has to have a conduct of doing business. And in that, exit has to be very clearly defined. In fact, most private equity guys come in today with the exit defined. In this case, in good faith, and I tell you, I think both sides work beautifully well with good faith and trust. Somewhere that trust thing has gone, and the complete trust deficit which has come in the last 10 years. And I hope and pray that today also the trust and that the whole confidence and faith is again reposed by both sides, and this matter is resolved. But I don't think, because the last 5 years, whatever we have seen, is going to be very difficult. So according to me, Supreme Court should have done a much better, judgment by having this, that this is the three-body committee constituted for arriving at a fair value on that. That should have, and that would have put the entire matter to rest.
Okay, no,
but I think it is open. And again, let me tell you one more thing.
Fine, but there is no. Yeah, so that's what I want to talk about. What happens next? I mean, what should have been done, should not have been done. There's no point really talking about that now beyond a point. The judgment's out. The parties have read it. It really gives Tata Sons the exoneration they wanted, which is why I started by asking whether this was, in a sense, quite a private situation. Because you see what Ratan Tata says. He talks about all the accusations and allegations made against himself personally. So that part is put to rest. Prabal, what do you make about the valuation? Because at the end of the day, both sides have made it clear that they want to part with each other. Cyrus Mistry was not interested in going back to Tata Sons in any case. He wants his 18% stake because his company got hammered in the pandemic and they need the money to move on. That's where the question really rests, isn't it?
Very true. I mean, see, there were three aspects, Tamanna, to my mind, in this very complex case, which the Supreme Court had to opine on. The first one was, of course, to actually define what corporate governance really means in a promoter-driven company in the context of minority rights, corporate democracy, management control, and so on and so forth. The second was what constitutes oppression and mismanagement. These two, I think, have been addressed and set to rest. The third was to act as an arbitrator and sort of define the parameters of an amicable settlement in a complex case of shareholding which they have in a private company, which has restrictions on transferability, etc. That area, I think the Supreme Court rightly has not got into it. And I've argued about this in Justice Arun Mishra's case, when he was handling the telcos spectrum case, etc. That is not the role of the Supreme Court. Having said that, I agree with the earlier speaker that, at least a format could have been done by appointing, 2 or 3 valuers, etc., because this is, after all, a large stake. And the gap between 1,75,000 crores and, say, about 1 lakh crores is a substantial one, and that needs to get resolved. The net result of this would be, of course, I'm sure the Tatas will have the sagacity now to go ahead and, at least in common perception, give a value and an exit to the Mistry Group, which is honourable. I think they will do that. If they don't, or if in Mistry's perception they don't, then the whole court case starts again right from the lower courts. So that is probably what could have been avoided, in my mind. Yes.
Mr. Mehta, I want to get your take on that, on what happens next. Will now the Tata Group have to come forward and start a negotiation, and that negotiation now will be from a position of strength following this Supreme Court decision? Perhaps both sides can come to sort of a settlement and, in a true sense, close the matter.
Well, you see, let's first understand what this judgment has done. Firstly, it has set aside the appeals made and the pleas made by the Mistry Group about mismanagement and majority oppression and lack of corporate governance. Now, all these issues have been dealt with by the court, and they've passed a final order that all the actions were in accordance with the law. The board decision to remove Mr. Mistry on 24th of October 2016 was correct. So this is one. Then the second issue was, you see, from the day that he was removed, Mr. Mistry got into a frame of mind where he started making personal allegations and outlandish accusations, preposterous accusations, personally against Mr. Tata and against the group. Now, those have also been discarded completely. They've thrown into the dustbin. So there is this settlement, finality on these issues. There's no doubt about that. And I must add that, making those accusations against Mr. Tata personally and the group, which has a history of ethical conduct throughout its 130 years, by the day, every day, I think this was totally hitting below the belt. And I'm glad that the Supreme Court has seen through that.
No, but Mr. Mehta, I would request you to focus on the question of what next. So now Prabal Basu Roy just said that he believes the Tata Group will come up with an honourable exit going forward. Do you think that that's the next step?
So these points were mentioned. So that's why I wanted to make it clear that these issues have been settled. There's a finality. Supreme Court judgment is the final thing. And there is a finality about it. Now, the question of valuation, it is something which the Supreme Court has, to my mind, rightly decided not to delve into it. Because this is a matter which is not their domain, and they have left it to the experts to decide in accordance with the Articles of Association of the company and in accordance with the provisions of the law. So this will take off from there. And it depends on what Mr. Mistry wants now after this judgment, after having read every line of the judgment. What do they want now? Do they still want to exit from Tata's, or do they want to continue, or in what form? And what they want in terms of exit, if they are thinking of that. Only once they make their position clear will the Tatas have to take a view on what and how to go about this. And those things, you see, will depend on the Articles of Association of the company and the company law.
Sure, you mentioned that. Yes, so we've seen a finality of, say, the first leg of the battle, where the Tata Group and Tata Sons and Ratan Tata feels exonerated of all the allegations that they feel Cyrus Mistry made once he was ousted from his position. So that chapter has ended. Will the valuation question also now go ahead smoothly in light of this judgment, or will we see another leg, another round of legal battles? Remains to be seen. But we'll end on that note. Thank you so much, gentlemen, for joining us today on the big corporate story of the day.